Senator Hughes, thank you very much for engaging our office, and I know Senator Johnson's office and many others have been involved in this. I see some of my colleagues from the House here. I certainly want to thank Representatives Howard and Johnson, and I believe Guerin is also here. Senator Hughes, you might know that clarifying the medical emergency exception has been a priority not only for me, but many in this chamber and in the House. I've pre-filed bills in 2023 and this session on this exact issue. Even before Roe was overturned, many of us talked about the medical community's concern about the potential uncertainty created by the language in the bills that were ultimately passed in 2021, particularly in light of the severe criminal penalties for medical providers. Now, I could stand up here and give a big old "I told you so" speech, but I won't. I wish we had addressed those concerns then and prevented some of the tragedies that have come to light over the last few years. But here we are now, and I'm glad that we're addressing this. I'd like to walk through some of the provisions in the bill with you to make sure that the public understands what this bill is. The first is the updated medical emergency definition. This bill makes it clear that a medical emergency is when a woman has a life-threatening condition that places her life at risk or could cause substantial impairment to a major bodily function. It defines life-threatening as capable of causing death or potentially fatal, and specifies the life-threatening physical condition does not have to be actively injuring the pregnant woman. Is that correct?
Senator, that's right, and that imminence requirement is very important because under the way the law was drafted before, and as you know, the medical emergency exception language that we used in the heartbeat law in 2021, we incorporated the existing statute, been on the books since 2011, so as not to create confusion. But nevertheless, in the last couple of years, some doctors, some really hospital lawyers, I think, read that language to say that they had to wait. So a mom's already got a dangerous condition, which we know is going to have really bad effects. But a few hospitals were taking the position, we have to wait until she gets really bad, even though we know she's going to, before we treat her. And of course, that was never the intent. So yes, ma'am, you're right. That clarification you just read is so important. The medical board addressed this, so did the Supreme Court. We want to put it in statute so there's no question. So yes, ma'am, that's so important.
They're used in many of the situations that have been reported recently. Treatment was denied to women until they were suffering from sepsis and potentially irreversible damage to their organs. To address these types of situations, this bill codifies the Texas Supreme Court's recent decisions in the Cox and Zarowski cases that the risk of death does not need to be imminent, and it makes it clear that a physician does not need to wait to treat a pregnant woman until she is physically suffering or harmed. Would you say that's correct?
Senator, that's right. If a mom has that condition and the docs can see where it's going, they don't have to wait until the mom gets even worse before they treat her. That's exactly right.
Senator Hughes, during the committee hearing, a number of witnesses testified, including some of the plaintiffs in the Zarowski case. They raised serious concerns that some of the changes made by the bill would allow the state to prosecute a woman who obtained or tried to obtain an abortion. However, as you know, the courts, going back to 1880, have held that women cannot be prosecuted in this situation. you and I had many discussions over the last several weeks. We discussed it, and now the bill has language to ensure that women cannot be prosecuted. Would you say that's correct?
Senator, that's right. You look at what sometimes is referred to as the 1925 statute, which even goes beyond that. And as you know, we have looked at every case going all the way back to statehood, and moms have never been prosecuted under Texas pro-life laws. And that's clear. It's always been the law, and that's reaffirmed here. You're exactly right.
Thank you. And for those listening in case you're wondering, that is in Section 20 of the bill. Another concern raised at the hearing is that some of the changes made in this bill would also impact ongoing federal litigation on whether the pre-road road statutes or the 1925 law, as you mentioned, has been referred to recently, are in effect. You've added language to this bill that by amending the medical emergency exception in the 1925 law, the bill does not affect whether the provisions of the 1925 law are reviewed or remain or have become good law, and will leave it in the hands of the courts. Would you say that's correct?
Senator, that's exactly right. Back in 2021, the legislature did pass legislation that says those pre-Roe statutes are still in effect. They are still there. So the legislature spoke to that, and that's in front of the Fifth Circuit right now. So as you say, we're going to leave that to the Fifth Circuit to decide, because the legislature has already spoken to that. Senate Bill 31 does not get into that discussion at all, because that's already been held by the legislature. You're correct.
Okay, and I appreciate your willingness to address these concerns. It's kind of been it was a moving target there for a while.
Yes.
Let me talk about what's not in the bill, okay? Are you familiar with the names of Lauren Hall, Samantha Cassiano, Dr. Austin Denard, Lauren Van Vliet, or Dee Allen? Sorry.
I have seen some of those names, yes, Senator.
Well, one of the difficult parts of preparing for this bill was reading about some of their stories. These women are all plaintiffs in the Zawoski case who had pregnancies where their fetus was diagnosed with anencephaly, a condition which prevents a fetus from developing a skull. And there's no chance of survival. Would your bill allow women in similar situations where there's a lethal anomaly to get treatment in Texas under the medical emergency exception?
Senator, Senate Bill 31 is about the life of the mother and the risk to the mother's life, and it does not address that important topic you raised.
Let's say they do not have the resources or travel out of state, then they would have to continue their pregnancy like Samantha Cassiano, like she did. To carry a pregnancy for months, knowing her child would not survive. Your bill does not make an exception for rape or incest. Is that right?
Senator, that's right. This bill is about the life of the mother exception, to make sure that the law is crystal clear and to make sure that doctors and hospitals know what the law is. And that's what this bill addresses.
Yeah, you know, that's a real hard pill to swallow, that there's not an exception for rape or incest. I hope one of these days this body finds it in their heart to allow that exception. This bill is a good step forward. Wish we didn't have to have this conversation at all in the first place. I believe this bill will save lives, which is why I'm supporting it, not only supporting it, but co-sponsor with you. I hope that we can come back and do the same for women who are dealing with devastating fetal anomalies, and women and girls who've survived the horror of rape or incest. Y'all, Texas women deserve better. Thank you. Thank you for answering my questions.
And thank you, Senator Alvarado.